Hi, I'm Denise and you're watching Law with Denise. So you've heard of Hedley Byrne and Heller 1964. You've heard that it was a significant House of Lords decision which impacted both English contract law and English tort law. But are you quite clear on the facts of the case, and do you know what was decided at trial, in the Court of Appeal and in the House of Lords? In this video, I'll take you through all those steps. I will explain what exactly the facts of this case were, and I will explain what was decided at trial, in the Court of Appeal, and later on in the House of Lords. So let's get started. So firstly, who are the parties involved in this case? The claimants were Hedley Byrne and Co. Limited. So that's the full name for Hedley Byrne. Hedley Byrne and Co. Limited. And they were an advertising agency. And the defendants were Heller & Partners Limited, a bank. So the full citation for this case is actually Hedley Byrne and Co. Limited and Heller & Partners Limited. However, in most textbooks, you will see Hedley Byrne and Heller 1964 as a citation for this case. And in this video and in other videos that I have, I will simply refer to the case as Hedley Byrne and Heller. Now, our claimants were Hedley Byrne, and Hedley Byrne had an agreement with another party called Easy Power. And the agreement they had with Easy Power was that they would put up ads on behalf of them, so on behalf of Easy Power. And Easy Power would pay them back on a credit basis. Remember, Hedley Byrne were an advertising agency, so they're going to put up ads for people. But with Easy Power, the agreement was that they would put up the ads and then Easy Power would pay them back later on a credit basis. Now, Hedley Byrne were not quite sure of the financial status or stability of Easy Power. So they weren't sure what position they would be in later on after having put up the ads on behalf of Easy Power, because they needed Easy Power to pay them back. So they needed to know if Easy Power actually had enough funds or access to funds and would have access to the funds in the future in order to pay them back. So what did Hedley Byrne do? Well, Hedley Byrne asked their bank to ask Easy Power's bank to confirm or to clarify Easy Power's financial status or stability. And who do you think Easy Power's bank were? Heller & Partners Limited. Now, when Hedley Byrne's bank asked Easy Power's bank, which were Heller & Partners Limited, to clarify Easy Power's financial status or stability, Heller & Partners, Easy Power's bank, gave a favorable reference. The reference was favorable enough for Hedley Byrne to decide to carry on with their arrangement with Easy Power. They clearly had some confidence that Easy Power were going to be able to pay them back at a later date. Unfortunately, Hedley Byrne ended up losing £17,000. Why? Well, in the end, they lost £17,000 because Easy Power went into liquidation. This meant that Easy Power was not in the position to pay back Hedley Byrne. So Hedley Byrne decided that they would take out a case against Heller & Partners. And this is how this significant case started. Now let's have a look at what exactly Hedley Byrne argued at first instance. So what did Hedley Byrne argue? Well, they argued two things. One, they said that Heller & Partners gave them those references negligently. So they said when the defendants gave them the information, it was given negligently. Secondly, they said the giving of those references negligently meant that the defendants, Heller & Partners, had actually breached a duty of care owed to them. So they were saying Heller & Partners owed them a duty of care, and that duty of care was to not provide the references negligently, and because they did that, that duty of care was breached. So they were saying Heller & Partners breached the duty of care held towards them when they passed on the information negligently. So what do you think Heller & Partners argued, the defendants? Well, the defendants argued two things. They said, firstly, we weren't negligent. And then secondly, they said, even if it can be shown that we had been careless when providing that information, we didn't owe Hedley Byrne a duty of care. Now, why did Heller and Partners say they didn't owe Hedley Byrne a duty of care? On what basis or on what grounds were they standing with this argument? Well, Heller and Partners are actually standing on the position of the law, or the position that was quite popular about the law in this time. And that position was that a party does not owe a duty of care not to provide negligent words to another party. In other words, the law at the time suggested or indicated that damages could only flow if it was shown that the defendant had provided a misstatement, so some kind of wrong information by words, but only if they had done so fraudulently or innocently, not negligently. So what Heller and Partners were saying was that the only way you could demonstrate that we owe you a duty of care, Hedley Byrne, according to the law, was if you could demonstrate that that information that we gave you about Easy Power was given to you either fraudulently or innocently. But you're arguing that we did so negligently. So that's why their second position was, even if it can be shown that we were careless, we didn't owe you a duty of care, because Heller and Partners were resting on the position widely held or agreed by people who were familiar with the law at the time, that one did not owe a duty of care to another party to not provide a misstatement unless that misstatement was provided either fraudulently or innocently. Now, what exactly happened at trial? What was decided? Well, Justice McNair was dealing with the case at trial, and Justice McNair thought that Heller and Partners had actually been negligent. However, Hedley Byrne didn't win at trial. Hedley Byrne lost. So why did Hedley Byrne lose if Justice McNair thought that Heller and Partners had actually been negligent? Well, Justice McNair based his decision on his understanding of the law at the time. And to his understanding, recovery for damages would only be possible if it was demonstrable that the parties had entered into a contract, and if they hadn't, they would need to demonstrate that a fiduciary relationship existed between them. Justice McNair also said, and this was based on his understanding of the precedent Darian Peake, he also said that in these types of situations, one would need to demonstrate that the defendant made their statement not negligently, but either fraudulently or innocently. And this could not be demonstrated. None of these things that Justice McNair thought the law required in order for damages to be recovered were demonstratable in this case. So that's why, even though he thought Heller and Partners were negligent, Hedley Byrne lost at first instance. Now, Hedley Byrne did make an appeal, and that appeal went on to the Court of Appeal. And what did the Court of Appeal say? Well, the Court of Appeal took a very similar stance to that taken by Justice McNair. They had similar understandings of the law to Justice McNair. They also thought that there needed to be either a contract between the parties before recovery could be made, or there needed to be a demonstration of a fiduciary relationship between the two parties. And they also thought that the precedent Darian Peake was that which they should be following. And Darian Peake did not allow them to give favor to Hedley Byrne, so the appeal was dismissed. Hedley Byrne made a further appeal, and this appeal obviously went to the House of Lords. Let's see how the House of Lords looked at this case. Well, there was a unanimous decision in the House of Lords to dismiss Hedley Byrne's appeal. But that is not why we say that this case is such a significant case which impacted English contract law and English tort law. It is not because Hedley Byrne lost in the House of Lords. We say that Hedley Byrne and Heller was a significant case which impacted English contract law and English tort law because of what their lordships said with regard to the law, because of the explanations and clarifications that they gave us with regard to the law in Hedley Byrne and Heller, and also because they created or established what we term the special relationship, which they said would from then on be applicable to cases with facts similar to those found in Hedley Byrne and Heller. So let's start by looking at what it was that their lordships clarified with regard to the law. First, they said that this idea that Justice McNair and the Court of Appeal had, that parties needed to be in a contractual relationship or a strict fiduciary relationship in order for the claimant to recover damages, was actually incorrect. They said that in situations such as those found in Hedley Byrne and Heller, where there is no contract, we're not looking for a strict fiduciary relationship. They said we're looking for what they termed evidence that the parties entered into a special relationship. Their lordships went on to explain what the special relationship is and the criteria that need to be met in order to convince a court that the special relationship has been established between the parties. So they made it clear that Darien Peak was wrongly understood by the courts, and they made it clear that other precedent that Justice McNair and the Court of Appeal seem to have been relying on were wrongly understood. And they clarified what the law was. They said, we're not looking for a contract and we're not looking for a strict fiduciary relationship. This is what we're looking for. We're looking for evidence that the parties entered into a special relationship. Now, in this video, I won't be explaining what is meant by the special relationship, nor will I delve into its criteria. But I do have another video in which I do those things. So that video involves me explaining what the special relationship is and what its criteria are. And the link to that video is in the description. So please watch that video after watching this one. However, what I do need to make clear, though, is why it is that Hedley Byrne lost. Well, their lordships applied the special relationship to the facts in front of them. And when they applied the special relationship to the facts in front of them, they determined that the special relationship had not been established between Hedley Byrne and Heller and Partners. And why did they think that the special relationship had not been established? Well, when we look at the facts, we see that there was a disclaimer issued by Heller and Partners when they gave the information or reference to Hedley Byrne. And this disclaimer, their lordship said, meant that the special relationship had not been established between the two parties. So Hedley Byrne lost in the House of Lords. Now, to find out more about the facts of the case and also to find out what was included in the disclaimer, I do have another video in which I explain these facts in detail and I explain what was said in the disclaimer. Follow the link in the description to watch that video. Until next time, I do hope this has been useful to you. Please remember, take care and like, share, and subscribe. Thank you. Bye-bye.